Good evening, everyone, and welcome to tonight's panel on the Child and Youth Wellbeing Act. I'm Kim Driscoll, and I'm your host for tonight. I work with New Brunswick Adoption Foundation. I'm one of the coordinators here, and of course, we are provincial wide. So, before I get started, though, I'd like to take a moment to acknowledge that we, the New Brunswick Adoption Foundation, are a provincial entity. We acknowledge that we carry out our work on the traditional unceded territory of the Wolastoq, Mi'kmaq, and Passamaquoddy peoples. This territory is covered by the Treaties of Peace and Friendship, which these nations first signed with the British Crown back in 1726. The treaties did not deal with the surrender of lands and resources, but in fact recognized Mi'kmaq and Wolastoq titles and established the rules for what was to be an ongoing relationship between the nations. We, the staff and members of the board, pay respect to the elders, past and present, and descendants of this land. We honor the knowledge keepers and seek their guidance as we strive to develop closer relationships with the Indigenous people of New Brunswick. As an organization focused on vulnerable children in the care system, we express these words with both humility and hope. So tonight, our goal is going to be to learn more about the Child and Youth Wellbeing Act. I'm really excited to have everyone join us, our panelists, but I really want to go into a little bit about NBF for about 30 seconds before we start our panel discussion tonight. So I want to remind everyone about our upcoming programming. We do have various support groups in English and in French, so you could always go to our website at www.nbadoption.ca. It's very user-friendly. The next webinar that we have is going to be on June 13th, and it's Hope After Sexual Abuse. And the next Building Families in English will be June 11th, and July 9th is in French. So please visit the website. If you have any questions about any of our programming, both English and or French, please contact one of us, reach out to us. We love the questions and we're more than happy to help. So now I get to the exciting part. We get to introduce our panelists. So we have Christian Whalen, Chair of CBA Child and Youth Law Section. We have Gavin Kotze, Office of the Child and Youth Advocate. We have Trevor Breen, Manager of Child and Youth Wellbeing, DSD. And we have Lana Irish, Adoption Social Worker, so DSD also. So I see, Christian, you are on mute, which you can stay if you'd like. I just want to give the heads up that we're going to go to Gavin for question number 1. And I want to let everyone know that you do have a spot there to ask questions. We will try and get to some questions that are specific about what the topic is during that time. So I'm going to ask Gavin the first question. If you have a question about that we feel we could answer tonight, you can put it in there. Mind you, if we don't get to your questions tonight, don't worry. We're writing down each question and we're going to send those off to each panelist in hopes that they will give us an answer back and send it back to you. Okay, so rest assured, we definitely want to gather as much information as possible. So, Gavin, thank you for coming tonight. When you consider the new act, can you tell us what are the main parts of it that you believe will affect the world of permanent care? Now, when we talk about that, of course, we're talking about permanent care, children in the care of a minister, guardianship, kinship, and adoption.
Yeah. I'm blanking. It's a giant act, but there are some incredibly important pieces to it. I think the most important are sections 5 and 6. So section 5, I'll talk about in a second, and section 6, I think we're going to talk about later. Section 5 is that the best interests of the child have to be the main consideration, the primary consideration in every decision made by anyone acting under the act. And section 6 is that the child's opinion has to be solicited and given due regard in those decisions. I should say, I was asked to say this, but I should say that I'm wearing I was asked what hat I'm wearing tonight and what my connection is to this act. So I should mention that I'm here in a professional capacity. I would love to be saying that I'm not, but I will be offering personal opinions. But really, I'm here as deputy advocate for legal affairs and advocacy, and it would be kind of disingenuous to say that, I'm not acting in that capacity because I'm actually in my office. I will be giving lots of opinions, I'm sure. They're not official opinions of the office. Only the advocate's opinions are official. He cannot be held responsible for what I say, only I can. So, and I don't mind that. I'm going to probably say some things that are inflammatory and maybe derisive. And we do have a representative of social development's head office on this panel, but anyone who knows Trevor Breen knows that he will hear those remarks and listen calmly somehow, respond professionally, apparently unflappable. I'm going to give it my best shot at making him flap. But the act is not the best act in the country. It's a very, very good act, a great improvement. This office has done extensive reviews of the child welfare system. We made many recommendations for change. Some of those made it into the act. Some further ones when the act was amended on the floor of the House, of the legislature, I should say, and then we've given recommendations around the regulations. Kind of confident that those recommendations will be incorporated. And really, it's all about now for us focusing on ensuring that the act is actually implemented properly by social development, by head office, by the regional zones, and all those organizations contracted to carry out functions related to the act. That's a pretty major challenge. It's probably the topic in which I'll be making some inflammatory remarks tonight. But I hope I'm not going over time with the very first question. The main parts that I believe will affect the world of permanent care, if we're talking about, permanency under the Act is defined in the definitions, and it could be custody by the Minister of Social Development, guardianship by the Minister of Social Development, as well as adoption. And that's where the best interests of the child provisions in the Act are going to have a really profound effect, because every decision that any social development employee makes, or anyone contracted by the department to make decisions, has to put the best interests of the child or youth above all other considerations. This is crucially important. No one at social development can make any decision or take any action unless the best interests of the child or youth is the primary consideration driving that decision or action. And one of the factors that the Act lists for determining what is in the best interest of the child is the importance of permanency for the child. And when the Act says that everyone at social development shall consider those best interests, it doesn't provide discretion. No one can say, in this situation, it wasn't necessary to consider that. They would be wrong to say that. So this would, I think, is the primary part of the Act that's going to be incredibly influential. There's also a purposes and principle section of the Act that we'll probably talk about later, but I'll leave it at that.
Great information. And of course, after each question, I said I would open it up to the rest of the panel. If you would like to add anything to this, feel free to do so. Would anyone like to add?
I'm good.
Yeah, I think maybe I can start off. And so I used to be with the advocate's office, but I am no longer. So I can speak even more unrestrainedly. But I would say, as much as I agree with everything that Gavin said, we've had an opportunity once in 40 years. This reform was a long time coming. And I have to say, for a 40-year reform to bring us up to speed with the state of child protection laws across Canada and globally, this effort was underwhelming. The advocate had prepared, a number of reports, two significant reports after taking a deep dive into the child welfare system in the province. So through their eyes and easier to build, came out sort of right in the midst of government finalizing its plan for the release of this new legislation. Although, in fairness, the department had the advocates' reports in draft for well over a year. So I think we could have done better. We could have positioned the province, as a leader in Canada in terms of implementing children's rights and respecting children's rights. So the two good things that Gavin mentioned, the Act's emphasis on child participation and best interests, which we'll be returning to in other questions. I mean, those are two of the four foundational principles of the UN Convention on the Rights of the Child. So, those are good things. But recent reforms in Ontario, they looked at, incorporating reference to the UN Convention on the Rights of the Child in the preamble to the child protection legislation. Similarly, in PEI, they've gone through an exercise where, they were very consultative in the approach that they took to law reform of their child protection piece. So they had draft legislation that was out for comment to the public, for over a year before finalizing it last December. If you look at the reforms that are underway in Quebec, they are, putting into effect the recommendations of the Laurent Commission, which is really taking Quebec in a very intentionally child's rights enforcement direction for child protection services and many other child related services in that province. So we're not, we're not practice leaders in Canada, and we're not practice leaders, globally in this sphere. So I'd say the one thing that is really heartening in terms of the law reform that's come about is there's one recommendation from the advocate that did make it in to the legislation, and that's the requirement for a 5-year review. So we're not going to have to wait another 40 years to have this conversation again, and I think that's critically important. It doesn't make sense that child protection concerns kind of languish at the bottom of the legislative agenda of the province, for 40 years. Not a lot of legislation includes a provision for mandatory review, but some legislation, particularly legislation that really, cuts to the bone in terms of its impact on individuals and respect for their fundamental rights, like the Child and Youth Wellbeing Act does. That's the kind of legislation that needs to be brought forward and updated regularly. So it's not just it's new legislation, let's give it a review 5 years from now and a once and done. It's a review 5 years from the moment of proclamation, and then we'll do it again on a regular basis every 5 year, and that's, I'm hoping, going to be a real game changer. Some of the good ideas that the advocate had in those reports, we'll have an opportunity to revisit, and we'll get a sense of how the change is working over the next few months and years, and I'm sure there'll be lots of good ideas for reform in 2029, 2020, 30.
Okay. Well, thank you. Now, Trevor, is there anything you'd like to add before we go to question number 2?
Absolutely. Thank you, Gavin, for that response, and Christian as well for, elaborating. I'll give some context of a little bit about my history, though, before jumping in. It's very similar to what Gavin did. So I've been a social worker in New Brunswick for 21 years. 17 of those years, close to 18, was frontline child protection. So investigations, ongoing child protection. I supervised child protection in the St. John area for about 12 years. So I certainly have a very solid understanding of the Family Services Act. So everyone knows on the call, I actually just turned 43. The act was older than me. So, I am excited to say goodbye to the FSA and hello to the Child and Youth Wellbeing. And there's beautiful pieces in this act that will certainly help solidify permanence for children as they move through, as families move through the system. One of the pieces certainly centers around priority of placement, Section 54, which is so very important when children, which I'll elaborate when my question comes along, as well as the best interest of the child. Certainly Gavin brought that forward. Also collaborative approaches, very key in as we work alongside of families, walk with them, we have to lean into our collaborative approaches more and more. So lots of key components to this act that I'm very happy about. And as certainly Christian brought forward, we're not going to wait another 40 years for a new act. It's going to be reviewed. What a beautiful opportunity for all of us on this call to work together to improve the system together. So, yeah, so overall, I'm excited about the Child and Youth Wellbeing, and no legislation is perfect. But absolutely, through our reviews and our work together, the next time around, it'll be even better than what it is today.
Well, thank you. Okay. So I'm going to go to question number 2, and this is for Christian. So from our prior discussion, you addressed the fact that the act is to allow more voices of the children to be heard. We know this needs to be a change in our culture. What kinds of changes do you feel need to happen in our culture to shift this?
Well, thanks for the question. I'm glad that Trevor brought in those points about collaborative approaches that are introduced, and certainly the legislation. As I mentioned, if it did one thing right, was to put the emphasis squarely on child participation and children's best interest as key components of children's rights and doing right by children. In terms of the culture shift, I think that New Brunswick has been on that path, and in part, thanks to the support of the Department of Social Development or Family Community Services, back in the day, by supporting the establishment of a youth and care network, by developing programs that like youth services program that are more intentionally focused on listening to children and young people where they're at. So we have some emerging practice. I would say it's still very much counterculture, and it's not as deeply embedded in everything we do as we see happening in other jurisdictions. So certainly, Section 6 of the Act, outlines that requirement to ensure that children's preferences and views are taken into consideration in any decision made in their regard under this new legislation. And so there's a strong principled commitment, and that's replicated in the regulations. So in the Child and Youth Services Regulation, and in the general regulation, we have references to the plans that have to be established for children in care, and for children's views and preferences to be taken into consideration in the preparation of those plans. So it's like it's in the legislation and then it's embedded in the regulation. Okay, that's a good thing. But globally, there's a really trending conversation around child-friendly justice. Just earlier this year, the UN Committee on the Rights of the Child released a concept note, and this month they've invited governments and stakeholders around the world to provide advice on what the new general comment from the UN Committee on the Rights of the Child should have to say in relation to children's rights to access to justice and effective remedies. So that's that's going to be an opportunity to explain in the world of child protection what does child participation really look like on the ground. In New Brunswick, we've had some good practice in relation to defining what child participation means in the context of youth criminal justice administration. So there were, on the Advocates initiative, a multi-stakeholder table of all the justice stakeholders that came together, thanks to funding from the Office of the Attorney General in 2021, 22, 23, to establish child-friendly standards, child-friendly justice standards in relation to the application of the YCJA. So it's one thing. Gavin is familiar with this. He and I have both had our share of experiences in, youth court, in provincial criminal court, when youth are facing charges, and they don't know what's going on in that process. They may often, because of the trauma that they're experiencing, be mouthing off at the judge and, not participating the way, you would want them to. But the process, is very adult centric and not adapted to really listening to children. Some of our colleagues, so I'm joining the panel as chair of the CBA Child and Youth Law section here this evening, and our colleagues in British Columbia have just organized a whole training session for lawyers around something they never learn in law school: how to talk to children. So this is actually the only kind of training of its kind in Canada, but it's a trending conversation. Lawyers, judges are increasingly invested in what do we have to do differently to be able to meaningfully communicate with children and young people? What do we have to do to change our processes so that they're not off-putting? And so the YCJA, for instance, allows for that through judicial conferences, and in the child protection world, we've seen that through family group conferencing. But what is the opportunity to really make these processes the norm and make court applications for child protection where, the child is on the sidelines, the center of decision-making in terms of the best interest analysis, but not actively engaged as a participant. So that's the opportunity that we have in front of us. And we have opportunities, I think, in New Brunswick to lead this conversation in Canada and to lead the conversation globally. We certainly have the capacity and the ability professionally to do that well. It's a question of whether or not we take the opportunity that the new legislation has created to really make that our focus. So I think it's good for the legislation to have these principles and standards in place. But how do we translate them on the ground so that increasingly when a child is placed, that their voice counts for something, right? we didn't hear that. We had quite a comeuppance, and it was already 10 years ago or more. I think 2013. I was in the Legislative Assembly when the Youth and Care Network had their first day of hearings. And Madeleine Dubé was the minister responsible at the time, and Premier Allward was down in the legislature, and we were up in the committee room with all these youth, and then like the hubbub went on through the Legislative Assembly, and people started talking to themselves like, hey, never mind what's happening on the floor of the Legislative Assembly. You need to go upstairs because there's a better conversation happening. And so the premier eventually, made his way upstairs and engaged with the youth directly. And I think that was transformative. I think it's been, in my professional experience, like working at the Child and Youth Advocate's Office for a number of years, those were the most transformative experiences that I've had, working in the YCJA context through judicial conferencing and bringing children's voices to the table when typically, for all kinds of good reasons, people didn't want to traumatize. Oh no, let's decide. Let's try and come up with a plan with respect to what's best for the child, and then one of us will put it to them, and we'll get their impact on. I mean, there's a time and there are cases where maybe that is the right approach, but generally, I would say from my experience, that is not the right approach. When you bring the child into the conversation, into the center of decision making, when decisions are being made, that's when their voice really counts. That's when they want to have their say. I've spoken to children, not necessarily children with lived experience in child protection services, but even like children with their own experience of divorce and marital breakdown, and coming forward to the advocate and saying, like, I have a story to tell. I'm not happy with what went on, in my relationship, with my dad 12 years ago in family court. And so they're scarred by these experiences of being excluded from the conversation. And I think a lot is going to have to change in order for that culture change to happen. I am encouraged that, alongside this kind of reform, last August at the law faculty, there was a national conference on access to justice. And the opening remarks were brought by Chief Justice Richard of our Court of Appeal. And he undertook to kind of reactivate and spearhead the access to justice conversation in New Brunswick. So there is hope that, and of course, like, access to justice is broader than, just the issues that we're talking about here. It's, for people experiencing homelessness, it's for people experiencing, marital breakdown and domestic violence, and all kinds of ways in which, access to justice needs to be improved. But in all those conversations, I think access to justice for children and young people, for children of adoption, should be front and center in the conversation. And that's the space that the Child and Youth Wellbeing Act has opened up. So let's take advantage of it.
Excellent. I am going to open this up. I'm going to start. Lana, did you have anything you'd like to add to that tonight?
I kind of do, but it's a lot to it's a lot to absorb. I guess I go back to I kind of wrote down best interest and started a bunch of times, and I guess I love the new act. Those who've talked to me about the new act, and I come from with a bit of a different lens from the other panelists. I come more from supervising frontline adoption workers, and living and sort of breathing the implementation of the new act and the learnings, and of course the things that we don't know yet that we're still learning and unfolding, and the things that we've been able to really take advantage of. And I'll talk about that stuff later. But what I'm really struck by is that best interest, since I've been with the department, I graduated as a social worker 24 years ago, and most of that time has been with social development. A lot of that time has been with Trevor in child, working collaboratively in child protection side by side, and then since 2015 in adoption. And best interest has been our North Star with the Family Services Act and this new act. It has always been our North Star. And my hope is that, and what I'm seeing and what I'm really excited about is the way the act is written, it just makes that a little easier, or a lot easier in some areas, and we're already finding that. And again, I'll talk about that a little bit more in my section. So I just wanted to speak to best interest. It just struck me when that word is best interest of the child, best interest. It is constantly in our language, in how we look at how we service our families and service our children. It's always at the core of it, in their best interest.
And for our participants that are listening tonight, you are going to hear that a lot, which is a really good thing, the best interests, right, of the child. So I love that it is really center of everything we're going to speak about tonight. We have about 2 to 4 minutes before we have to move on to the next question. So I'm going to see if either Gavin or Trevor have anything they'd like to add to what Christian said. Trevor, do you have anything you'd like to add?
Well, just kind of want to, looking at Lana's comment around the North Star, I completely agree. If we're talking about a cultural shift in New Brunswick, if we all focus on the best interests of children, making sure they have great outcomes, if we can all focus on that component, the cultural shift will come. From there, it's then around education, it's around information. We have to be very intentful around that piece. So if we keep our eye, as they say in Newfoundland, on the prize, but I like Lana's kind of component better, on that North Star, and that is around the best interests of children and youth and young adults, which is really the center of this entire act. That is the beauty, I think, of the Child and Youth Wellbeing Act. And that cultural shift, what I'll say, and I will say this in a couple of moments as well when I answer my question, it's not a switch. We have to be very intentful. And again, as a group, as a system, we all need to work together. And what the beauty of even of this call, the Adoption Association, our allies with the Advocate's Office, frontline, even at Central, kind of moving that piece forward, which is great.
Right.
Gavin.
Yes. Gavin, do you have anything you'd like to add?
I think, well, of course I agree with everyone. I think it's more difficult. I think it's as difficult as Christian explained. And I think it's actually a culture shift that may not even happen. Now, I don't mean that as an offensive remark against social workers. No one goes to study social work to do harm. They go to help people, quite obviously, right? Social workers are people with very large hearts, thick skin. They do great work. Then they get it. This is my personal experience in any case, or at least my perspective. They can get into a system that boxes them in. The Act expands what they can do from the Family Services Act, the previous Act. It's not as good, as Chris was saying, as the Ontario Act, which even predates the Child and Youth Wellbeing Act. The model is right there for us to take. Now, we've got a review, a 5-year review. That should actually be happening in 3 years, because we're already 2 years into this bill passing. It took 2 years of it essentially languishing before coming into force. So, and then every 7 years thereafter. There's a lot of work to do. And there's a lot of work to do. And I think in what Lana was talking about around education, training is incredibly important. And let's give you one example. I've had 3 cases in the last, I'd say 3 weeks, maybe 4 weeks, with a parent wanting to have a custody agreement with the Department of Social Development. And the Act, for legitimate reasons, I believe, provides that parent loses their legal authority, and the minister takes the legal authority of the child. We don't need to get into the reasons for that, but no good parent wants to sign a document that says that. And when that's communicated, when a child is in incredible distress, let's say, and a parent the child's beyond the care and control of the parent, not because the parent doesn't love the child, and not because the child doesn't love the parent, but because the child is going through extreme mental health crisis, for example. And that parent hears from a social worker that they are going to lose all legal responsibility and authority for their child. Two of them haven't done it. They won't do it. The important thing is training, because that provision has to be read in conjunction with the best interest of the child. And family connection is one of the primary factors to assess best interests. Do people know that? I don't believe they do. Will people be able to actually, in the system, and I'm talking about group home workers and foster care workers, anyone making a decision under this act has to, is obligated to, must consider the child or youth's views. And that's not as, common as we might hope. And it's also a resources issue. I'll just throw that out there too. The act can say one of the most wonderful things in the world, and the regulations can be incredible, and the policies and practice standards. But if you are a social worker with 30 cases or 40 cases, are you really seeing that child or youth enough to actually get their voice, to get their views and preferences? It's challenging. I'll just say that. So that there's this disjuncture between the act and reality that I think is going to be very difficult to breach.
Thank you for that insight. It's very educational, and I love the way that you're speaking in regards to some of the situations that you're coming across. We have participants in the audience, and I'm sure a lot of them can relate to what every one of you are saying. So I am going to move on to question 3, and this is for Trevor. So Trevor, can you please unpack the concept of priority of placement and the process that social workers move through when a child is not able to live with their parents? How do you see this impacting the process if the minister was to apply for guardianship of that child or youth?
Well, thank you, Kim, for that question. I guess this is my soapbox moment. So, and I excuse, I am a bit long-winded, and as I was saying earlier, I am from Newfoundland, so hopefully I won't take too long to move through this. But the Child and Youth Wellbeing Act is a great step forward, and I truly believe that for children, youth, and their families. And it's truly built on the important pieces of culture, community, safety, and permanence. And we've already chatted about permanence thus far tonight. The act really legitimizes, and that word really kind of stands out from my partner here, Lana, the work that we as social workers want to do. An important part of the legislation is Section 54. Now remember that, Section 54, known as Priority of Placement of Children and Youth. That falls under what's called Part 5 of the Act, which is Child Protection Services. So really, what does that mean? Well, the minister shall place a child or youth with one of the following persons listed in priority. The first one would be a parent, meaning that we, as a social worker, must consider the other parent when a decision is made to remove a child. And then B, akin to the child or youth, meaning that we as social workers must consider those that have a close relationship with the child. Now, that could be a blood relative, could be an auntie, it could be an uncle, could be nanny and poppy, or a non-blood relative as well, like a coach, a teacher, for example, considering other types of care. So priority of placement makes it mandatory to consider kinship caregivers as the first placement option when children and youth cannot live at home with their parents. While this is a cultural shift, it legitimizes the good work that social workers want to do in ensuring that children and youth are living with those that know them, that have a relationship with them. I'm sure everyone on the call has nieces, nephews. Probably many of us have children. We would want them to be with someone that they know. So this shift is aligned with the best interests of children, Section 5, as Gavin chatted about it a couple moments ago, and it ensures that connection to community and culture. So why is this important? Why did we do this? Well, research shows that children who remain within a kinship network or with family have a sense of permanence. They have a real sense of identity. We have lots of studies that suggest, as compared to children that live in traditional care settings, children in kinship care experience fewer behavioral issues, fewer placement breakdowns, as well as have higher reunification rates. So overall, we see a reduction in trauma. As we move forward using the guiding principles of the Child and Youth Wellbeing Act, we as social workers will need to make the intentional efforts to find family and kin. To do this, social workers need to take necessary time and effort to developing trusting relationships with children, youth, and families. To assist in this effort, social workers can use strategies such as echo maps, genograms to fully understand and support family networks in children and families. Also tools like family group conferencing that Christian had chatted about a couple of moments ago. So through this process, social workers, guided by the Child and Youth Wellbeing Act, shall capture the views and preferences of all children in either assessing or family planning to ensure that children and youth have a voice. In making decisions, we must measure the impact of that decision or action on the child's permanency with their views in mind as outlined through Section 6 of the Act. Now, there are times where we know where we're not going to be able to capture the child's views because of perhaps an inability in expression. Perhaps they are age. In these situations, again, we must lean into a person who knows the child or youth to best capture their voice. Or we must, for example, weigh the impact of decisions on their routine, on their culture, their traditions, language, religion, identity. Again, all from that lens around how will this decision impact the child's permanency. As social workers and as youth and young adult workers working on their child and youth wellbeing programs, absolutely we are committed to the best interests of children and youth, as Lana mentioned a couple of moments ago. So we must remember that children have absolute rights, whereas parents have contingent rights. When working with children and youth, we must work from the perspective of their best interests, again highlighted within Section 5. This section outlines the responsibilities as social workers and youth and young adult workers that we shall consider in all aspects of our work, mandated through the Child and Youth Wellbeing Act, around the needs of that youth. Ultimately, as a result of the priority of placement, we should see more children and youth living with kin and less children living with in those traditional models of care. Now, Kim, this brings me to the second part of your question. Once the minister applies for guardianship of a child who has moved through that process, by law, we should have exhausted any potential family members or potential kin providers for that child or youth, for example, through the use of collaborative approaches such as FGC, IRC. Now, in some situations, if the child or youth is living with kin, instead of applying for a guardianship order, we can now apply for what's called a kin custody order, mirrored after the BC legislation, for example. This will allow for the transfer of custody on a temporary basis to kin. And again, we should see a reduction in guardianship applications there. But if we do have to apply for guardianship and the child or youth is with kin, they've already been previously assessed. The requirements under our regulations for kin are the same, either in protection or in adoption. This is powerful as it again supports the child or youth's connection with family. And I know that Lana is going to expand on that piece in a couple of moments. So we have to remember there are many pathways to permanency. We need to meet children and families where they are, taking into account culture and traditions, just to name a few.
Okay, great. Before I open this up to the rest of the panelists, Trevor, can you clarify what FGC is and IRC?
Oh, great question. Sorry. Those acronyms: Family Group Conferencing and Immediate Response Conferencing.
Okay, and the other question that I have for you is, could you tell us a little bit or expand upon whether or not there a rule or law now, policy that states that, let's say a child comes into care through child protection and kin, of course, is looked for immediately when this happens, and then the child goes into guardianship. Is there that 30-day wait in order to look again for kin before guardianship is granted to adoptive family.
I'm not sure I understand the question, to be honest, Kim. So maybe I'll say it back to you. So if guardianship's granted, is there a 30-day window where we would need to look for kin before? Okay, I guess, the only 30-day window after a guardianship is granted, there is a window of appeal. So I'm wondering maybe that's what the individual is thinking about. That would be the only 30-day window that I would be aware of after a guardianship is granted. Maybe
they may
Lana.
be asking about before it's granted.
Pardon, say that again, Gavin?
Weren't they asking about 30 days before? I mean, custody, I'm sure Trevor can explain custody and guardianship and the differences between those, but is the question about if a child comes into protective care, child protection services, under a temporary care measure, there are timelines that have to be met, and then at a certain point, the minister would have to apply to a court for a custody order. They could ask for a guardianship order, but that generally doesn't happen right away. I mean, I guess I don't understand the question either. But I was thinking it wasn't, I thought it wasn't about after guardianship. I thought it was talking about before a custody agreement or order was made, or guardianship order or agreement. If, let's say, a child was placed in a foster home or group home, is there an obligation to continue to look for a kinship placement? Was that the question?
Yes, like I'll be as specific but yet broad as I can. When it comes to different participants that we have, we're finding that the situation arises where the child, let's say, has been in a foster home, for, let's say, 2 or 3 years at some times, and then they reach guardianship. So the courts have granted guardianship. Now, as a foster home, some of those foster homes are pre-adoptive also, right? There's word that there's this 30-day wait that after guardianship has been granted, that they have to, before they place a child with a pre-approved adoptive home, that they have to look for kin during those 30 days. Is this something any of you are
So during those 30 days that Trevor had referenced, there's what he means by appeals. So whoever the guardianship board, so whoever, the birth parents say, they have 30 days in order to appeal the guardianship decision. So during that appeal period, we can't place a child for adoption or move forward with any permanent plan per se until that appeal period is over. And that is the only 30-day period, like Trevor had said, that I'm aware of.
Okay, well, that'll clear it up for some of our participants. And if it doesn't, we'll just ask them to send you their question for more clarification. Now, without going to the next question, did anyone else want to add anything to the information that Trevor presented to us there? Kristen, did you have anything you want to add to that?
Yes, lots. But I
Maybe
guess
if we can keep it for about 2 to 3 minutes. No.
sure. That priority of placement that Trevor walked us through is encouraging in terms of, well, I think one of the things to my mind, what the new act opens up is, many more opportunities for kinship placement. And we had this long period of waiting for kinship regulations and a reform around kinship care that started before this legislation came into being, and that finally is kind of perfected, I think, with the new Child and Youth Wellbeing Act, that that makes kinship placement more of a norm. And to my mind, that's a good thing insofar as it is respectful of, UN guiding principles on the placement of children outside of their family unit. That if we're placing children in alternative forms of care, we should really look for adoptive families. We should really be looking for an alternative family environment, not group home care. And I think one of the drawbacks of New Brunswick's system that the advocates reports, shed light on was in New Brunswick our over reliance on group home institutionalized care and the harms that can happen to children. Sometimes it's out of the frying pan into the fire, and so these are all like really encouraging developments. Again, I'd like to ask the province and ask us collectively to reflect on what are we afraid of committing to in terms of committing to the rights of the child. The law reform piece that we saw, there were two things I said at the outset that we did right in terms of respecting children's rights, is respecting best interest and respecting children's voice, and those are foundational principles. And other than that, when the legislation came in, the only other right of the child that was reflected was a guarantee with respect to the child's right to privacy. And so immediately the advocate, responded, and, even though we only had 30 days or 3 weeks or 2 weeks to turn around in the legislative session with the way legislation rolls here, Mr. Lamrock responded very quickly, and there were some floor amendments that were brought in. And so you saw additional references to educational rights and health rights, brought in to the legislation in section 8.1, through floor amendments. I was encouraged, just, prepping for this review, to see that additional provisions were added in December of last year, just prior to proclamation, that expand the list of children's rights to include also reference to, their rights to participate in culture and recognize their heritage and to participate in the arts and culture of their communities. And so things that are foundationally important for children and young people, they're now reflected, but they don't reflect actually. These are rights that are kind of created by statute in New Brunswick. They kind of parallel some of the important rights of children outlined in the global treaty that Canada has ratified, but we're afraid to speak the word. We're afraid to reference it. And then the rights that are most important in terms of the priority placement of children, they're kind of passed under silence in this legislation. So the key components in a child protection regime of children's rights guaranteed to children all around the world are the right to be protected from all forms of violence in Article 19, the right not to be separated from their parents unless it's necessary in their best interest, made by a decision made by competent authorities subject to judicial review under Article 9, and Article 5 that talks about parents as being the ones who are primarily responsible for their children's care and upbringing. Section 18, the same thing, that the government has to support parents in that role. So all the things that are really kind of instructive for child protection, we don't speak about in this legislation. And I think when it comes to priority placement, it's good, but we should have those reference points, because we saw in past years that oftentimes placement decisions would be made, by agreement, but without even a formal agreement. So there's an arrangement, and children languish kind of in limbo, in legal limbo, with respect to who's in charge of them. But we're all busy with child protection files, and so that file, hey, they're good, they're safe, they're not in danger, so auntie's looking after them, but she has no legal standing, right? That's a violation of the child's right. Yeah.
Thank you, Christian. I'm just going to have to end it there. But Trevor, we do have one other question for clarification. Could you clarify where, when you're speaking about kin, where foster families fall under that? So they know the child, like they've lived with the child for 2 years, they are a pre-adoptive family. So where on the priority of placing, they would like
Yeah.
to know where
So
would
there is
foster
no, yeah, there is no priority of placement in regards to adoption. So the priority of placement is in regards to when children come into care. So Lana will expand a little bit on that, Kim, when she kind of moves into her component. But that's really when once a guardianship is granted on a child or a youth, it really depends on a number of different factors, taking in, again, as you had said earlier, this, people will hear this quite a bit tonight, the best interest of the child. So there's no priority of placement for adoption. That is for when children come into care. Prior to kind of guardianship, we are continuously working on ensuring that they're with family. Lana, correct? Yeah.
Yes.
Yeah.
Yep.
Okay, so Lana, do you want me to go into your question right away? And maybe that can lead into this.
Sure.
Okay, so Lana, can you tell us about the general changes to the day-to-day application of the adoption program in regards to this new act?
So just so people have context of where I'm coming from. So I'm not coming from necessarily, where Gavin and Christian and Trevor are coming from. As I said earlier, I'm coming from more of a frontline lens and more of the practical components to implementing the act. It's also important to understand I oversee an adoption program in the Southwest Zone, which is like Charlotte County through St. John to St. Stephen. So I'm one of the 4 zones. And so when you're looking at child protection and prior to guardianship, that is not a piece that I'm involved in. I'm only involved with the children and the staff that I have, working with me. We're working with children that already have a guardianship order. So I think that's important to note that. So
Yes.
the child protection pieces of it, guardianship has already been granted and the child is already in the permanent care of the minister once they come to our program. So when I'm looking at, there's a couple of things that jump out. The practical components that really have impacted. The number one is what we've been talking about is kinship. And we have right now, I think 4 to 6 on the go right now, kinship adoption. The word kinship adoption made us so excited because what it does is it changes the process for kinship in order to adopt and have be adoptive parents and have that legal standing as adoptive parents. So what happens, we have got a couple of cases where they've come over to guardianship to our adoption program already in kinship placements that have already been identified. I would have been involved in planning meetings prior to them coming to us to talk about child's best interest, how the best way moving forward. I usually have met with these kinship families to talk about what the process would look like. And prior to this new act being rolled out, they would have had to have done all of the same things that any other adoptive family would do, including taking the PRIDE training. And so, there's something else that I'm missing big. The SAFE assessment, the SAFE assessment, which anybody on here that's an adoptive parent has participated in a SAFE assessment. So we won't be having a SAFE assessment. We will be doing what we call a validation tool, which we're actually being trained on in June. So just to give you perspective, we have a family that's come through that's going to hopefully adopt a second cousin. And it means that they're going to have all those family connections. They're participating in birthday parties with cousins and aunts and uncles and extended family and have the benefit of their history, their culture, and all the things that a lot of us take for granted. And they don't have to wait until PRIDE starts up again in September. That wouldn't end until December, which means they wouldn't be able to start the SAFE assessment until December, or January of 2025. So we're actually able to start 3 kinship that don't have to go through PRIDE and go through all of that. We're able to actually start as soon as we have the validation tool to start those assessments this summer, we will be able to assess them and provide permanency much quicker to these families and to these youth. And then we've got 2 cases that youth that have come over, and after coming over to us, we've had family members who have come forward, because what sometimes happens is family members are not maybe feeling comfortable coming forward before guardianship, or they've heard of guardianship. And so we are exploring those families as well. We're very early stages, but again, if they pass, or if they make it through the kind of pre-screening or eligibility criteria at the very front end of it, then we can look at doing the same thing with these families, as I was talking about with the other 3, where they don't have to wait. And maybe by the time we get everything done, maybe they would have missed the Pride in September. Maybe they would have had to wait till January or March, right? So it's just really making it so much easier for families to stay together, and for children to be adopted by their kin, whether it be family or whether it be, exactly like Trevor said, a coach. We have one situation is somebody worked in a resource with a child and is no longer there, but understood that there was a guardianship order and had come forward and said, I'm really interested in adopting this child. And it's a child that wouldn't typically be challenging to place because of their very challenging behaviors, but this person knows who this child is. They already have that connection, and when you have that love and connection, then, like Trevor had said, less likely of placement breakdown, and keeping the culture and the history. And so that's a really big game changer for us, and we're living it right now. And the minute that this was rolled out, because we already had those few kinship that were already coming through, that has been an immediate positive impact for us. We're very, very excited. A small thing that I feel like I have to mention for those who have already been approved, which may not seem as big and startling as kinship, would be the fact that we don't have to do updates every single year. This is really impactful when you're first approved. It can take a bit, or when you're first going through the process and you hand in your criminal record checks and you hand in your medicals and your references. By the time you go through that PRI training and your assessment, all of those might have been expired by the time we're ready to assess you, and then we have to get you to do it all over again. So we have heard a lot of positive feedback from our staff, as well as from our adoptive families, saying it's so nice that we don't have to do it every year. We can do it every 24 months. That's been wonderful. Another change would be around, a couple changes would be around our subsidy program, and the fact that we have gone from, if you're in post-secondary, we could extend you till you were 21. And now from the ages of 19 until 26, if you're in post-secondary, we continue to provide services to those children, which I haven't seen what that looks like yet. It's still in the works of how that's going to look, but we're really, really looking forward to that as well.
Excellent. I have to say, I've been hearing the exact same happy, positive feedback in regards to the 1 year, not having to, redo your CR check, etc. So that definitely is a plus for our families.
And when we're talking about all of these big things, I feel like that might seem like a little, but and I guess, and I feel like I'm in a little bit of a bubble when I'm listening to Gavin and Christian, because, and maybe it's because I'm more on the ground level. When I'm hearing them talk about best interest, and when I hear about the voices of children, and I think about the work that our team does with before the act, after the act, always moving forward, all of the conversations and discussions we have with our children, if they're cognitive, if you've got like a 2-year-old, it might be a little bit different than a 5-year-old or an 11-year-old, but we're always talking about what do they want? What are they looking for when we're looking at matching children? They're part of that process. There's a lot of prep work that goes into preparing our children for adoption and ensuring that their voice is heard. And so I just feel very, very optimistic, and I feel very excited about, and if anybody who knows me hears me talk about adoption before the act, with the new act, I've always felt very passionate and very positive about the work we do. And even as I think Gavin talked about the boxes that we're in, absolutely boxes that we're in, but I feel like I work with people that don't tire of trying to find ways, creative ways. And again, the act opens it up more and it makes it easier, but constantly finding ways to meet the best interests of the children, hearing what their voice is, no matter what box might be around us. We just find creative ways of doing that, I feel.
Okay, so I have a question that I've been asked to ask, and it says, what does this act mean, practically speaking, as far as the increase of the age that the children can or will be under the care of foster families, professional care homes, etc.? I ask this as I was told children will no longer age out at 18 or 19 years old, but rather into their mid-20s. Now, you just spoke about if you're in post-secondary education, but this doesn't specify anything about post-secondary education. So has the age limit changed of a
No.
child?
So from my understanding is in the post-adoption program, and if you're not in adoption, but if you're child in care and you're in a foster home or a group home, that it would be the same, that you're in post-secondary secondary or post-secondary education and in need of support, or just in post-secondary or secondary education, then it extends up to the age of 26.
So
thank you.
I guess I don't know if I'm clear. You must be, not if I'm correct, Trevor. My understanding is you must be enrolled in secondary or post-secondary education in order to be eligible.
That's changed a little bit. So
Okay.
it's now up to the age of 25 inclusive. So when we're talking about children that are perhaps at the age of 19 under guardianship, let's say that word, under guardianship, or maybe was under a CA during that period of time, probably not a CO if they're turning 19, or maybe they were receiving YES services, we are able to offer services up to the age of 25 inclusive. What those services look like really will be tailored to the needs of that youth or that young adult. Remember that in my first response, I kept saying young adult, 19 to 25 inclusive, really built upon those, the pillars. We're working closely with Dr. Melanie Doucette out of Quebec around that piece. And as Lana said, those programs are now just starting to kind of roll out as they are, certainly brought forward to staff internally. We're also going to be doing a lot of education around that piece.
Okay, so I see that.
I just had a question for Trevor on that, and I wondered about that, that break in service. So is that being addressed? Like it used to be under the old rules that, you had to go directly from care into post-secondary,
that's been for the sake of better language, abolished. I don't know. That's probably not the best word to use, but it is really, children that are in care, we know have they're in care for a reason. It's abuse and neglect, right? So, in those situations, they have trauma. Now, so they're going to need additional support as they kind of age, not age out, as they age, right? As they mature. Now, I remember being 23. I still depended on my parents. It's the same thing. Children that are in care, living, under the province's care, they need that support, and in some situations, more and more support than what I would have even needed at 23.
And it's important to note that would be the same for the subsidy program. It used to be like if you weren't open already to the subsidized adoption program, you couldn't come back later for services, and you can the same way that Trevor had just said. The only difference is from the age of 19 to 25 inclusively, you would need to be enrolled in post-secondary.
And that's so encouraging, and really interested in following that conversation with Dr. Doucette and the equitable standards of transitioning from care. But I think for this conversation this evening with the Adoption Foundation in particular is just a healthy reminder that if we can achieve permanency and we can get adoptive placements for these children, in younger years, like all of this becomes moot, right? And there's still a difference, from aging out at 19 or 25 versus, having a permanent family. So glad to hear that the legislation, keeps us focused on that goal.
Now, Gavin, I want to see, we're only about 10 minutes behind, but last time you didn't get a chance or opportunity to speak on the last question to give your feedback. Do you have any feedback for the question that Lana was posed to you and the information that was brought forth?
No, I mean, I think, I echo Chris. It is really heartening. And I think that, when Lana, you say that you operate in a bit of a bubble, it's nice because adoptions, although fraught with challenges historically in New Brunswick, that process is not as challenging, I think, under the new act as other processes in terms of resources. There are inevitably, the thing is this, you get individuals who are, let's say, a child or youth in the system, or someone advocating for them, or a parent with questions. And what tends to happen, unfortunately, is that people they interpret legislation restrictively, and here's the rule, and they say, well, it doesn't say I can do X, so I cannot do X. And that's the exact opposite of what should be done, right? You should always give a fair, large, and liberal interpretation to law. And so really a lot of it comes down to, you've got this act, the regulations, there are regulations in force, but they're being amended. What are they going to look like? And when it comes to the situation with, offering services up to the age of 26, if a young person is in post-secondary education, there are, there's a potential that this can be interpreted restrictively, like, well, they already had one chance at that, therefore they can't. They did it when they were 22, didn't work out. Now they're 24, they're trying to do it again. No. So we just have to have people thinking the way, Lana is thinking, where it's like, it's not one kick at the can. You get, you can, it doesn't say I cannot, the act doesn't say I cannot do this. The regulations don't say I cannot do this. It's in the best interest. Everything has to be guided by the best interest of the child or youth, which is a bit of an issue, I guess, interpretation wise, because you're not a youth anymore after the age of 19 under the act. But regardless, if it's in the best interest, I'm going to do it, right? That's the thing. And I think, the stuff that Chris traditionally would have dealt with when he was at the advocate's office and that we deal with today is people afraid to make decisions that are in the best interest of children, and without clear direction. And what is really needed, obviously, is to allow social workers the discretion to utilize their professional expertise and make those decisions, and not feel that they're going to be slapped on the wrist as a result of it. So those are the real challenges. All I would say to anyone listening who has questions about this kind of stuff, you can reach out to the advocate's office. You can reach out to the Child and Youth Advocate's office, and we will be diligent in finding answers for your questions and trying to ensure that the act is followed as expansively as it's meant to be.
Well, I think that brings us perfectly into your question, Gavin. The act refers to the best interests of the child. Can you give us some examples of what this could look like and how it should be considered when parents are requesting access to resources through social development?
Yeah, and so this is parents requesting access to resources, so adoptive parents, presumably.
Yes, but we're also talking about, let's say an example, which I think someone brought up earlier, is where a child, due to their trauma and or abuse, etc.,
Right.
can't be parented by the parent and is, let's say, put into a group home for that resource. So is this in the best interest of the child to have the parents' rights taken away or removed? So I think you actually touched on that a little bit
That was me.
earlier.
Yeah,
Yeah.
that's right. And I should say, even though you have in one of those instances, the parent was upset because the social worker had said, well, you have to give up all your legal rights. And that's all they said, because the social worker is dealing with a new act and the training, really hasn't been robust in it yet. What the social worker should have said is, legally, the minister has to make decisions, right? They have legal authority to make decisions over the child, and there are reasons for that, because if a child was taken into custody, or custody agreement or order, it's a 6-month thing, and then it can be repeated for 4 orders of 6 months each. But prior to that, under the old act, the minister didn't have full legal authority, and social workers would be having difficulty getting a child to a doctor's appointment because the mother, or father wasn't allowing it. And so the reasons for to allow the minister to allow social workers, right, acting for the minister, to have that legal authority is to avoid that. But it doesn't feel good as a parent. And what that social worker should have said was, look, you can cancel this agreement. There's 30 days notice and it's canceled. And also, the best interest of the child has to guide this agreement. And one of the factors of that is connection with parents. So we will be informing you of every action taken and getting your input on every decision we're making. That's what should have been said. But it wasn't, because that social worker presumably didn't know that. And, in another case, the parent was just really upset with the form that was given, because it just seemed so austere and stark. Please sign here to give up legal rights over your child. And, so the form could be amended to provide the real context for what this agreement is, and to provide some assurances to parents. So I think those are all changes that can be made. In terms of best interests of the child, when and how it should be considered when parents are requesting access to resources, not in that context, but in, let's say it's an adoptive parent, but the child that he still has needs. Still, social development has to make every decision and consider every request in light of the best interests of the child or youth, above all other considerations. And that includes, if you look at the act, it would say, one of those factors is the child or youth's physical needs, mental needs, or emotional needs, developmental needs, and any care or treatment required to meet those needs. So if a parent is asking for those kinds of supports, a social worker, whether adoption services or child and care services or child protection services, should be saying, okay, well, obviously, I have to consider what are the best interests of this particular child or youth in terms of, these mental health needs or physical health needs, etc. And they should, of course, also ask the child or youth, right? Because that, as we've talked about, is required under the Act. And then they can make an agreement with an adoptive parent or a prospective adoptive parent, right? In terms of providing social services and various supports. And they should be offering that It shouldn't be for the prospective adoptive parent or a parent who has adopted a child to somehow know this. And so that should be communicated. I'm sure it is. I would hope it is. Anyway, and if the answer is no, I think there's an obligation on social development to say, look, we're going to say no to this particular request, but you have a right to require us to review that decision, right? So there's an appeal mechanism right in the Act. And I think that should be communicated. It shouldn't be something that's, hidden away for, that one parent in 10,000 who actually might read this Act and find that, or hire a lawyer to do that. And then, the other thing is the regulations have to be explained, right? So what does that look like? It spells out what I think Lana and Trevor were talking about. The minister, the minister's delegates can provide this kind of support up to age 19 for social needs, health needs, or 26 if this child or this young person is over 19 and is in post-secondary education. That would include college, not just university. I think that should include really any accredited program, right? So you want to, again, make sure that if it's like, well, what's this? It's some online course. It's not even a college, and it's not a university. What is this program? Well, I don't think it counts. Social workers should not be thinking that way. They should be thinking, is this in the best interest of this young person? And is it post-secondary education? Yes, it is, because secondary education is finished. That was high school. So they have to, implement this expansively, not thinking, oh, it doesn't say I can do this, I better not. That's really crucially important, and it's the biggest issue we see in the child welfare system. Apart from the fact that we have this wonderful idea and this wonderful law that says all of these things will happen, like priority of placement. But when you get to those priority of placement provisions of the Act also say that social development has to consider the proximity of the child or youth's habitual home. And it's no secret, children are placed hours away from their habitual homes because there aren't group homes and foster homes. There aren't enough of these. There's a resources issue. Anyway, so there's all of that. And of course, I guess the last thing I'll say about that is adoptive parents and prospective adoptive parents and children and youth have access to all services offered by all government departments. And, of course, social developments, child and care services or adoption services should facilitate access to those other services, whether they're in education or health or early childhood development or in social development itself under, disability supports, etc. And they should also be referring people to the advocate's office, because the advocate's office, it deals with very weighty cases, it's true, and systemic issues, that's true, but it's also a good facilitator to guide people to where they can actually get services.
Excellent. Okay, so I will offer, if we can keep it to 2 minutes and under, Trevor, before I go to Christian, because he's going to weigh in on this term also, do you have anything you'd like to add about what Gavin has said?
No, I'm going to focus on Principle 3 of the Act in my question, so I think that kind of will fit in. So, yeah.
Excellent. Lana, do you have anything that you could keep to under 2 minutes that you'd like to add?
I don't think so. Nope.
Okay, great. Okay, so Christian, off we are to you. So, go ahead. Okay, so legally, how does this term, the best interest of the child, look, and who determines that this is in the best interest of the child?
Yeah. Well, first off, thanks for framing these questions and providing this space, within tonight's conversation to really unpack and focus on best interests of the child. I also am intent in trying to, keep us within our time. And I think what I can add in terms of what legally does the best interest of the child look like, just a comment that, the requirement under the Act is that the best interest of the child be, it doesn't use the primary consideration language of the Divorce Act or the convention, but it's basically saying it has to be the determinative factor in decisions affecting children, and that when we determine the best interest, we should look at the following factors. Now then it lists a number of factors that are relevant in the context of child protection, but it's a separate list of best interest factors than you'll find, for instance, under the Divorce Act, that regulates, custody arrangements in the civil courts. But I think both pieces of legislation just, refer to the fact that you have to determine the best interest, taking into consideration all the circumstances of the child, including, right? So there's nothing exclusionary in the list of factors that are enumerated in subsection 5.2 of the Act. And so my sense is that, all those other factors enumerated in the Divorce Act, for instance, are often relevant factors in child protection. And so we should be reading best interest broadly. Who has to make that determination? Well, we all do. It's not really just for the court to determine in a guardianship application or a custody. It's really for, the frontline social workers and for adoptive families. I think if we're talking about the culture change that we want to see, we all have to check ourselves, with respect to this commitment to children's voice, child participation, and children's best interest. How do we, within our own family settings, and particularly within adoptive family settings, respect child participation and children's best interests in decision making that goes on in the family setting? That's the challenge, right? The child protection system, is only there kind of as a default if these other fail-safes in families, in foster care settings, in group homes, and in adoptive family placements fail. So maybe there is something that has to be done in relation to our adoptive family placement and our foster home, placement training, to put more emphasis on safety and best interests on best interests as opposed to, say, safety. I think the big switch in this legislation, that's why I want to just maybe wrap it up here, and because I think like the answer to Gavin's question number 5 about what do parents who are requesting access to resources through social development think that best interest means for them. I'm hoping that the answer to that question is also in Trevor's answer to question 7, because it to my mind, that's the big change with this legislation, and it's in the name, right? We wanted standalone child protection legislation, but it's called the Child and Youth Wellbeing Act. And that's the big conversation globally in child protection, circles is what is the best model of state intervention? Should governments be intervening in family when children are at risk and engaging to protect children? Or should governments be engaging to support families and to help families thrive through a variety of challenging circumstances? I think too often, Carrie was asking in the Q&As I saw, what does the Act mean, for families with FASD or autistic children? What What happens when an adoptive family placement breaks down? And I think those are the hard questions that this law reform is going to be measured by. Is if we can switch from moving in to protect and remove to protect, and instead have systems in place that are there to support families, and support families prior to adoptive placement and to support families post-adoption placement, recognizing that oftentimes, children who are placed have needs that go above and beyond the needs of a normal child. And too often, like the old system where we just say, family life is the private sphere and government shouldn't intervene. Government should only intervene when the child is in danger or at risk. And so that old protective interest was forcing us to think in ways that, like, it's all on you, mom and dad, until there's a problem. And if there's a problem, we're going to be there in a big way. But in the new way of thinking, I'm hoping under the Child and Youth Wellbeing Act, we'll be thinking about supporting parents every step of the way.
Yes.
And especially for families of children with special needs. We have to recognize that not every family situation is the same. And some parents have a much bigger challenge that they face in raising children with special needs, and government has to be there in a bigger way. And the way government, steps in to help those families is through social development. So that's.
Okay. Well, thank you very much. And in interest of time, we're going to move straight to Trevor's question, and then we have Lana after Trevor. So, Trevor, the act will shift the practice of how people view and understand the role of child welfare. Can you tell our audience what this shift will look like and how the new act can help with meeting the needs of the children and youth using trauma-informed approaches?
Well, thank you again for that question. And again, this is an exciting time to be a social worker working within child and youth well-being. Tonight we talked about reviews, either the advocate's office reviews, certainly Christian and Gavin brought up a couple of reports that were written. Also important to know the George Savory review back in 2019, the NBSW, as well, New Brunswick Association of Social Workers, moving away from acronyms, certainly has done a lot of connections with staff internally, as we have as well as stakeholders. Through all those conversations, we see a lot of clear messages, or I see clear messages. So in that, we need to be able to move towards clinical practice. In order to do that, we need to ensure that we create plans that are child and youth centered, but as well that they're family focused, ensuring that children and youth are central in all of our decision making. We need to practice from a strength-based approach, practice from a trauma-informed lens, intervene earlier into families to reduce recidivism, and that families need to lead decisions. As we move forward, we will walk with those that we serve. As child protection social workers, this is critical, again, that we walk with those that need assistance. So using trauma-informed lenses in our decision-making, for example, children and youth will be part of decisions. All decisions will take into account the best interests of children and youth. We must capture their voice, capture their preferences. We are as well now beginning to invest in kinship. We were chatting about that earlier as part of our priority of placement here in New Brunswick. As well, the minister is now utilizing collaborative approaches, again, engagement with families to ensure that connection for children and youth. The Act also and its accompanying regulations allow for flexibility for Indigenous parents, Indigenous children, and as well extending services to young adults up to the age of 25 inclusive. The Child and Youth Young Adult program is rooted in the principles of equity. It is designed to recognize the unique circumstances of each child and youth. Very, very excited to launch those programs, or that program. I could expand on each of those points, but I really want to focus on this evening principle 3, which is really the overarching principle of the Act, and that's early intervention. In all of our work moving forward, we will take a proactive response in both design and delivery of services to children and youth. This ties into the overarching principle again of child and youth well-being, that principle 3, which really states that early detection and intervention are essential in matters in which the well-being of children and youth may be at risk of harm. This act is based on the principle that early detection and intervention are essential in matters in which then that the well-being of children and youth may be at risk of harm. When engaging with families, children, youth, and young adults, kin, and community, it is from that perspective ensuring the well-being of children and youth. This approach requires community and government partnership to ensure children and families in the province are supported, preventing them from entering protection programs. Research has shown investing in our front door services is a critical step in improving our system. The intention here is to continuously improve, again, the system so that services to children and youth and families are offered sooner and more intensely, preventing an escalation of complex needs. Through early intervention, services will be weaved through the programs offered for children and youth well-being, again, starting at the front door and then continuing through the life and journey of that child. During my first response this evening, I spoke about the importance of clinical practice, empowering families, empowering social workers. To lean into a trauma-informed approach to practice, we will be moving towards principles of practice, for example. Gavin had spoke a bit earlier about being boxed in. Well, we want to move away from that here at Social Development, creating pillars, for example, that are child-centered, culturally safe, strengthening families, supporting carers, partnering, collaborating, and creating a learning culture within SD, not only within SD, but within our systems. While again, these are draft pillars, this will help guide our work as we move forward. While culture is changing, culture change is not, again, a switch. This is really over a period of time. So this process will take time, not just for us here at SD, but all of us as a system, including many of us here tonight as leaders and participants. We're developing our programs and our approaches from trauma-informed lenses, ensuring the system is responsive, keeping children safe in their families and in their communities.
Beautiful. I love the idea of this wraparound proactive strategies and supports that our families and our children need. Lana, why don't we're going to end with Lana tonight. Due to some time constraints, we are reaching 20 to 10 in the evening. So we were able to answer a couple of the questions in our chat, but again, please don't feel that your questions won't be answered. Each panelist here knows that we're going to send the questions out to them to get answered, and then we'll send that back to you. So that is all being written down. So Lana, what message are you hoping to deliver to the audience tonight?
So many, so many messages, but I'll try to keep it short. And I added things on as, Gavin, Christian, and Trevor talked. I'm like, yeah, that's really good. I could build on that. Trevor answer before mine couldn't be more fitting, because this is what we're doing. When I walked in the door in August of 2015 into the adoption program, MB Adopt hosted an event that October, which they did every year before COVID, in Moncton. And it was all about attachment, childhood trauma. And so, again, I'm in my bubble, I feel like, but I feel like the culture, and you guys are talking about this culture change. For me, this is not going to be a culture change. We're already there. We've been there since the moment that I ever stepped in the adoption program and prior. This is just the switch of the switch for us is this act opening the doors for us to be able to do more easily what we've already been doing and trying to achieve and have been achieving. And it's just going to result in less barriers for us in order to do that. So, and again, to what Christian was saying, that's our focus isn't on safety, because it doesn't usually have to be. It's very rare in the adoption program that we're having to focus on safety. from the minute we get our children that come from, for the most part, child protection, trauma and abuse, attachment issues, they're not easy kids a lot of the time. So from the minute we're looking at matching and placement, from placement day, we have signed, if they're eligible for the post-adoption program, the subsidy program, we've already signed that agreement on placement date. That is a requirement of us. So we're already supporting the family, and we follow them for a year, and we don't, and sometimes longer if they need it, because we're not pulling the rug out from under them. We're not, we're making sure that they're ready for that finalization. And then most of our, I would say, if I had to do a stat, probably 98% of our families are open to subsidy upon finalization because of who these children are that come into our program. And so they are getting that support. And so I'll just give you a little small example. I remember being on a call with Mary Mary McCormick, when we were talking about the the development and writing and what will make things easier. And we're talking about the menu of services. And it was so prescriptive. And so it is, one size fits all, which we know. And again, we would have to be so creative in that, and so many exceptional requests. And so when we're talking with just one little line about counseling, that's on the menu, as if it cannot be accessed through community resources and free resources in the community, under certain circumstances, we can pay for that privately. And what we've added in a bunch of other things under that menu of services, just under counseling. And then she added, based on the conversation she had with me and Cheryl Moore, our very, very passionate subsidized adoption social worker, not limited to. Those 3 words, I cannot tell you what that means for us. And it just opens the doors to other possibilities around being creative and talking about exactly what we've all been talking about. How do we support families to be successful? And I just want to mention breakdown for a bit. Just to be clear, a breakdown does not happen when a child comes into care. The only time we have a breakdown is when we're looking at a complete severing of that relationship. Like when families are asking for help and going to the department for help and having their child placed into care, it's from my perspective, when we're working collaboratively with protection, it's about supporting that family, supporting that child, recognizing that at this particular period in time, that child's needs are beyond their capability. Sometimes other siblings are not safe in the home. It's not penalizing. It's not judgmental. It's there to support families and work on reunification. So that all being said, I guess I want to tie it up with saying that it's been, as we've said, it's been a long time coming. I think, a lot of us were not around when 80, we might have been alive, but we're certainly not working in this field in 81 when the Family Services Act dropped. The fact that we are part of this in the here and now, I can't tell you how exciting. I can't believe that I still get to be here to see a new act. And my biggest ask from people is be patient. We're still learning. My gosh, I'm still learning. Trevor filled me in on something that I didn't know tonight, and I did my research as best I could before I came. And so there's still things that we're not going to know. And if, as Gavin pointed out, questions and miscommunicate, misunderstand. If you think that something's being misunderstood, reach out, connect. Certainly in my program, if somebody's feeling like, I don't think the social worker's getting it, or ask for a meeting. I would, if it's in my program, I would be happy to talk to anybody that would like to have those questions sorted through and worked out and have a better understanding. I may have to go and get my own clarification. I've been doing that quite a bit since this rolled out. And so just don't be afraid to ask questions, and you're not going to be penalized for that. You're not going to be judged for that. It's a new act, and we're learning and we're figuring it out, and we're still in training, and we're still figuring it out. So, but I can't believe that we get to live and exist in the department right now, or in the field of child welfare and working with children, that we get to live in this time where this act has been introduced.
Excellent. What I'm going to ask of people, as I'm doing some thank yous tonight, I'm going to ask you to grab your pen or paper or your cell phones and write in notes. That way you'll be prepared. I'm going to ask each panelist for either their email address, telephone number, whatever it is that you would like to give out in case there's questions that are specific to your topics tonight. So I'll give you a minute to grab those pen and papers. So I would love to say thank you to Christian and Gavin and Lana and Trevor for coming and doing this tonight. As you could tell by our participation and the interest in this, that it is monumental to professionals in the field, outside of our fields, and also to our foster parent, kinship, parents, former youth in care, adoptees, everyone, that we get this information out. So this platform was phenomenal in explaining some of that information that we really need to reach everyone. Oh, I was going to be specific, but really it should be for everyone to know. So I'm going to start with Lana. Lana, how would you like to be contacted?
So email would be great.
Okay.
So it's Lana. Are you going to send it out, or would you like me just to?
No, I've been asked to make sure that everyone states their contact information.
Okay,
So if you
sure.
just say it now, then that way our participants will have it.
Perfect. So it's Lana, Lana .irish, IRISH, like the people in Ireland, at gnb.ca.
Okay. So Jessica is putting it into the chat as
good.
Lana is saying. Now, Gavin, you put it into the chat already. So Gavin Kotze at gnb.ca. And Christian, if someone had a question for you, how would you like them to contact you? Oh, we can't
I can
hear
give you
Christian.
Christian's
Oh, there you go.
personal home number.
Yeah,
Okay,
you
sorry,
can
Christian,
you
we
can
couldn't hear you.
at christian.whalen at gnb.ca. I just noticed that my name tag was misspelt here, so it's WHALEN.
Okay, well, thank you. And Trevor has added his, so Trevor.Breen, Breen, at gnb.ca. I'd also like to take this opportunity. We were very lucky to be able to have this in both English and French, so translation. That's due to the generosity of the Department of Social, GNB, sorry, for providing us with those interpreters. So overall, I would really just like to say thank you for everything that you communicated tonight, and thank you for being part of the child welfare system and reform that we all are looking forward to. And I'm sure you'll get some questions in your emails in the next upcoming week or two. Have a wonderful evening, guys. Thank you.
Thanks a ton, everyone.
Thanks so much.
You're welcome.